Namaskar. In today's episode of my law lecture, I'll be discussing about the postmortem report and its legal implication. The importance of a postmortem report in any criminal trial is very important from the defense point of view as well as from the prosecution point of view also. Since it is a technical knowledge or it is done by person who are specifically skilled in his profession, so understanding the nomenclatures or the expression used in the postmortem report is very much essential for effective cross-examination of the doctor who conducts the postmortem of a deceased. Before we discuss the postmortem report and its ancillary topics, we should remember that whenever a doctor comes to the court to give his deposition, we must show utmost respect to him because he is a person specially skilled in his field. We should try to elicit the answer from him in either in yes or no. If he wants to give an explanation, we must caution him at the beginning itself that if he wants to give an explanation, he will seek the permission of the counsel. We will not debar him from explaining certain things which he wants to explain, but we have to keep him in control at all time so that from the defense point of view, he may not create further confusions in the court if his postmortem report is inconclusive. Now, first, let us understand what is a postmortem report. We refer to the postmortem sometimes as autopsy or necropsy also. It is a medical examination carried out of the body after the death, and it is carried out in case of sudden, unexpected or unexplained or any suspicious or unnatural deaths. In autopsy, it is the duty of the surgeon who conducts the postmortem examination to examine each and every part of the dead body so that the exact cause of the death is known so that we can arrive at the truth. A complete autopsy is necessary to substantiate the version of the eyewitness or whether there is any confliction between the description given by the eyewitness and the nature of injuries found on the dead body. It is said that is a poor autopsy is worse than no autopsy at all because it will create all sorts of confusion during the trial which may lead to a serious miscarriage of justice. Now, who conducts autopsies? Autopsies are normally conducted by registered medical practitioners who are specially skilled in those discipline of medical science. Now, autopsy is initiated on the requisition given by the investigating officer. Along with the requisition to the doctor who conducts the postmortem examination, the IO will also give a brief facts of the case along with the inquest report or any other relevant evidence which is necessary for the examination of the dead body will be provided to the doctor. Why this is important? Because suppose there in the inquest report, the nature of injuries and the type of injuries are explained. Those are done by a layman. But during the postmortem examination, when the doctor conducts the postmortem examination and he finds that there is discrepancy between the inquest and the postmortem examination, then he should bring it to the notice of the investigating officer that these are the discrepancies which are noticed in the postmortem examination. So kindly take note of it when you conduct the postmortem examination. And normally we find that during postmortem examination, the doctor is assisted by technicians or other associate or his junior fellows in the department. Quite often put a question that why postmortem is conducted during daytime. There are some religious belief in India that funeral is not held during the daytime, so postmortem is conducted during the daytime. But there are also a scientific reason for not conducting the postmortem during the night is that during the night, due to the light of the tungsten or fluorescent, whatever be that in the room, the color of the dead body may look different than it looks on the daylight. The color of red may look something different in the tungsten light. So it is necessary that the postmortem is done during daylight so that the exact color is known. But now there are instruments to measure the color temperature of the dead body also there in regard to the color of the wound, bruises or laceration, whatever be it. And similarly now lights have come where you can set the temperature of the light in Kelvin to daylight. Normally 5400 Kelvin is the light temperature which you put in the light to give the daylight effect. Now, where is the postmortem carried out? Postmortem is normally carried out at the morgue or at the forensic science department of a medical college, or sometimes in the district civil hospital. But there are situations where the dead body may have decomposed to a certain extent, or the dead body has burned to a certain extent that it is not feasible to transfer the human remains from the place of occurrence to the morgue. Then postmortem has to be done at the place of occurrence itself. During examination of the dead body during postmortem, doctor normally doesn't fill up the postmortem form. He takes notes, or his assistant takes notes in a slip of paper, and later on from the notes they transfer it to the main report. These notes are the contemporaneous record or the primary document which should be preserved and handed over to the investigating authority, because during cross-examination of the doctor in court later on, question may be put that when did you fill up the postmortem report? Did you rely on your memory or did you rely on your notes? If the doctor said on my notes, then the next question will be definitely put that where are those notes? So these notes are required to be preserved by the investigating officer or the doctor. Now, once the postmortem is completed, the doctor gives an opinion in regard to the cause of the death. Read that opinion. Remember that in many cases in India, the wearing apparels are not sent for forensic examination. In a case of homicide or in a case of fire, it is necessary that the wearing apparels of the deceased must be properly sealed and sent for forensic examination, because that may be an important evidence during trial or in the process of investigation. Now, sometimes during postmortem examination, it is not possible to know the immediate cause of death. Say in a case of poison or underlying disease condition, you may not be able to know the cause of death. Then the organs of the for histopathological examination or laboratory examination. When you talk about histopathological examination, what are the organs says? It may be the heart, lungs, kidney, which are or body parts or some part of the brain, which are sent for histopathological examination to know the underlying cause of death, whether it is due to poison or whether it is due to underlying disease condition, etc. So if a doctor doesn't know the exact cause of the death immediately after the postmortem is done, then it is important that he gives a preliminary report, and later on when the final report may be given, when he gets the histopathological report. In many of the police manuals of the states, there are clear-cut guidelines that the postmortem report, preliminary or the postmortem report, has to be given within a week from the date of conducting the postmortem examination. Now, let us examine some of the provisions of law which are necessary for a lawyer before he cross-examines the doctor who conducts the postmortem. The next important point which we must keep in mind is that the Indian Evidence Act under section 45 deals with the opinion of expert. The general definition of an expert is that an expert is a person who has devoted time and study to a special branch of learning and thus is specially skilled on those points on which he is asked to state his opinion. If you look at section 45 of the Evidence Act, it describes that expert means one who is a specially skilled person, and that's why I have marked the specially skilled person in red. And when we are talking about a person in a particular branch of law like medical, so we put in this word science under red highlight. Likewise, the statement of the doctor which has been reduced to writing in the postmortem report is also treated as the previous statement of the doctor reduced to writing during investigation. So a doctor can always be questioned in regard to contradiction or in regard to corroboration which he has given as evidence before the court. Now, what is contradiction? Suppose in the postmortem report he says a particular fact, and in the court he tries to bring a complete new fact or explanation, then we can prove it as a contradiction by pointing it out to him specifically that this type of explanation which you are now trying to give in the court is not there in the postmortem report, and it has to be accordingly proved in accordance with law. One must remember, since under Section 45 of the Evidence Act, the opinion of the expert is always an opinion. It is not conclusive. Let me explain it in a more simple way. Suppose the postmortem report is inconclusive. It is not foolproof. It casts doubt on the way the investigation was done during the postmortem. Even if the postmortem report is discarded, but there are specific eyewitnesses which says how the incident has occurred, then the court may rely on the evidence of the eyewitness and convict a person. The point which a defense counsel should remember during cross-examination is that suppose you rely on a medical literature to confront the witness, the doctor who has come to depose before the court, you have to show the medical authority or the literature on which you rely to contradict the doctor. He must given an opportunity to explain the discrepancies in his report and in the medical research. The point which we should keep in mind is that whatever the doctor has observed in the postmortem report must be properly documented. But so far the National Human Rights Commission guidelines are concerned, in case of custodial deaths or death due to police action, the entire postmortem has to be videographed and photographed. And there are specific guidelines which says how the photograph has to be taken and how the videography has to be done. Last but not the least, a lawyer who wants to do an effective cross-examination of the doctor must study books on human anatomy, must study the principles of medicines. And if you like my video, please do subscribe to my YouTube channel and click on the bell icon for latest notification on my law lectures.